Okay, so in this video, we'll be discussing the different types of intellectual property rights that you can acquire or rather you can use to protect your business as you navigate the industry you're in. But the bias will be a bit to technology companies, but it will just be general. Also, it will also be relevant to the general public. So the first type of intellectual property protection that I'd want to discuss is called a trademark. So the purpose of a trademark is to protect the brand of a business. So the brand of a business can be expressed in the form of a logo, can be expressed in the form of a name. If you're a perfume company, maybe in the form of a scent. If you are if you're a company that deals with specific products, even maybe in the phrasing of those products or your tagline. So even a tagline is something that you can be able to trademark. For example, if you think a bit of my generation, when you're young, I used to hear something called usiseme mkate sema superloaf. So something like that can also be trademarked, the combination of names that are unique to your brand and your brand identity. The other part that I wanted to talk about, in addition to the trademark, you can also get a copyright. So a copyright is a protection that extends to literal works. So if you are, or anything that you create as an artist, whether it's a song, whether it's a book you've written, whether it's art. So even in the sphere of technology, you can copyright source code. So source code in the form is source code in the sense that if you're building source code for a particular system or app or website, you can be able to trademark that source code because it's a literal work. So you can be able to copyright it. And when someone violates your copyright, you can be able to go after them for copyright infringement. Similarly, for the trademarks, you can also go after someone for trademark infringement. The third thing that I wanted us to discuss is also patents. So patents are another type of intellectual property protection that extends to inventions, and they largely categorize into two. So they're usually method patents and system patents. So you can patent a method of doing something. This mostly applies to medical products or drugs or something along those lines, but also you can patent systems. So system is a way of doing something. A good example is, for example, Uber, how Uber has the ride-hailing solution. So if they wanted, they can actually patent that, the platform they use, the system that they use. So that's what connects with patents. Another one that's closely related to patents, they are called utility models. They are basically an easier patent, because again, when you're discussing patents, you'll realize that, or rather a bit about patents, they are a bit complex and can be a bit difficult to get, because for you to get a patent, you need to make sure that whatever you've created is new. So it is a new thing, it's also an inventive step, and it's a step forward for mankind. So the standard is very high. But if you create something that may not be necessarily new, it may be an adaptation of something else, but it's still an inventive step, it's still a step ahead, you can get something called a utility model registered. The third and the last and final one that I wanted to discuss is called an industrial design. So for an industrial design, it refers to protections of how something looks like. So you can protect the outward appearance of something. So if your product has a way that it's known in terms of its appearance, an example being the Coca-Cola bottles, then you can be able to protect them as industrial designs. And when you protect them as industrial designs, it means the outward appearance, the shape is protected, and no one can be able to replicate that shape without your consent. And for all of these ones, for patents, for industrial designs, for for copyright, if someone uses whatever you protected by the specific right without your consent, you can go after them for infringement. And you can get, among other things, you can get an order to have them cease and desist. So it means stop doing what they're doing. You can get compensation. It means they pay you for that and all of that. So if something is trademarked for someone else to use it, they need to get a license from the owner, the inventor, the owner, the creator, the person who owns the trademark. So that's a bit about what I wanted to highlight briefly today. My name is Meshach Masibo. I'm a lawyer who specializes in offering legal services in technology. I am also a patent agent and will be happy to have any conversation with someone who has an issue around some of the things that we've discussed.